to go, sir.
Yes, yes. Yeah. Yes. Yeah. Section 45. Today's topic will be, we have yesterday concluded the various judgments, judgments in rem, judgments in personam, where judgment cannot be challenged when uh, uh, under the provisions of section 42, you will not be in a position to lead rebuttal evidence when the judgments are conclusive. Judgments under 43, public rights are established, can be used. Then section 44 speaks of when fraud takes place, everything can be challenged. So today's topic will be the opinion of third persons when relevant. Third parties, the experts here, expert third person, they're all not connected to your cases. They're not connected to your cases. Let us start from here, section 45. When the court has to form, this is used both in civil cases and criminal cases. Please note that the various types of experts who can be examined by the parties, I will take you through in the matter. They are known as expert witnesses. Okay. Now let us understand the section illustration. Then I will give the explanation. When the court has to form an opinion upon a point of foreign law, underline the word number one, foreign law. There's a specific provision contained in the provisions of section 38 of the Evidence Act. Foreign law के बारे में problem नहीं आया था. When you open, I'm just explaining to you each by word. Section 38 में we uh, run through when the relevancy of a statement as to law contained in law books. That is one thing. Please note that. यहाँ पे for 48 may, because foreign expert can explain to you when international arbitration is going on, when you have to explain certain treaties, then you can resort to the provisions of the foreign law or the opinion given by the author who wrote the books. Like for example, Salisbury's laws of England will give you everything in detail as regard the position in England. What is a common law of England? Common law in England में there are no written statutes like India में है. Everything is based on precedents. Okay, that is a foreign law. Or science and art. So sometimes matters come before the court of law with regard to certain experiments. Certain all this in murder cases, you take the DNA test, you take the forensic test, you take the palm test. Yes, some scientific experts say. And who has skill? The doctor gives opinion. The weapon is capable of causing injury, can be caused. Whether the postmortem injuries, antemortem injuries, how they are called. Only scientific experts, the doctors, they can give it. You and I, the judges are not expert, lawyers are not expert. So foreign law के ऊपर evidence can be laid, that is section 38 के अंदर, or scientific experts can give, forensic experts come into play. When you want to determine the whether the child belongs to the father, paternity develop करने के लिए DNA is very common. 112 के अंदर, though it is conclusive, but the window is kept open by the legislature, saying that if the husband had no chance and access to the wife, the child is born, he can challenge it. The suits are filed challenging paternity. Even I never had access to her. My marriage took place about 6 months ago and she delivered a baby. It is not my child. He may take up the plea that here. I never had access to her and I dispute the paternity. It is not my child. So the scientific expert, the DNA test conducted by these scientists can be used here, DNA, RNA. Then relating to art here, यहाँ पे art के बारे में भी there are scientists, there are sculptures. ये particular मूर्ति तिरुपति की particular मंदिर की कभी बनाई गई? Who are the artists here? Who has drawn this particular painting? These are all experts can give it. These are evidence you and I cannot give it, nor the court will give it. So artist, but painting may be in dispute with regard to some. Nowadays, the painting, art of a painting is running into several crores of rupees. You know that all the eminent, the artists, उनके तो auction sale तो जाते हैं hundreds of crores of rupees. So when the dispute takes place with regard to whether genuine painting hai, nahi hai, the artistic evidence can be opinion, can be sought by the court of law of the artist. Or as to identity of the handwriting. So you may take up the plea that here the will which has been produced by my brother claiming to be me of my father and grandfather, it doesn't contain the true signature. It's a bogus, fraudulent. He has produced a fraudulent will for claiming the entire property, which is not so. I dispute the correctness of the writing. This is not a signature. So, in order to determine whether the handwriting, whether it's in the handwriting of your grandfather or father, whether the sale deeds contain the true signature of your parents or your signature, you have filed a suit for a declaration that the agreement or the document which is contained is a sham, colorable, bogus be set aside. So the court is not, you are not an expert in determining the handwriting. So you need the assistance of a handwriting expert. Though, of course, handwriting expert itself is not a conclusive evidence. It's a supporting evidence. It's a evidence which can be corroborated. So, apart from Section 45, under Section 73 of the Evidence Act, when you see that a court can compare the handwriting. When you just open, इसके अंदर handwriting के बारे में जब issue आया, please open Section 73 खोल लीजिए आप. There is to be read along with it here. Comparison of the signature writing or seal with the other admitted or proved. The court can compare it in the present. The court may call the witness here. Look here, you said that this is not your signature, you sign it. Your wakalat namadisi. In order to ascertain whether the signature writing or seal is that of a person or whom purports to have been written or made, any signature writing seal admitted or proved to the satisfaction of the court to have been written made by the person may be compared with the one which is to be proved, although the signature writing seal has not been produced, proved for any other purposes. So the court may direct any person present in the court to write any words, figures, or purpose of the enabling the court to compare the words or figures or written with the words so and so. So plaintiff and defendants are litigating that the plaintiff will say that the agreement of sale has been signed by you. You dispute the correctness. You may tell the court, my lord, may kindly compare the signature. I am here. I am prepared to give it. Now the court can also ask any of the parties present whose signature is in doubt, please come and sign before me. So the court itself will compare. That if the court itself is not confident, the court wants some corroboration, they will appoint the expert, handwriting expert under Section 45 to give opinion as regard the identity of the handwriting expert, because they have a special skill knowledge. So they have some training. They have undergone particular course. They have given many such reports in the court of law, various institutions. So the court will grant the take the help of a handwriting expert who are. So the opinion is given. Opinion the court may diye not sufficient. The person who gave the opinion must come into the box. He must step into the box and say that, yes, I was approached by A party, B party for giving opinion as regard the signature contents. I have closely examined, perused the same with scientific expert. But Durbin se dekha, wo dekha, whatever experiment he is having, he has to give opinion. So merely because he has given opinion is not binding on you. You have a right to dislodge his opinion by the other side examining their own written. So when there's a conflict of opinion, the court will decide, the court will compare the resort to section 73. It is the discretion of the court किसका opinion लेना चाहिए किसका नहीं चाहिए. Okay. Then or finger impression are relevant. Now finger impressions are relevant. आपने पिक्चरों में देखा होगा किसकी तलवार के ऊपर, छुरी के ऊपर, रिवाल के ऊपर कोट पकड़ा था. And many people take precaution to use a handkerchief, isn't it? Glass के ऊपर. You have seen this in old Hindi films and all. So fingerprints experts are there. um, जो भी कत्ल करने आया आदमी उसके fingerprints, footprints, there are footprints experts who had come here. That will determine when there is no evidence to show that here direct evidence, the circumstantial evidence, the footprints of the person who came, they will not lie. Now even in Aadhaar card, they are taking your footprints, आपके हाथ के, palm के, सब लेते हैं because each person has a different system. He is the Almighty has made it differently, and the footprints cannot mislead you, cannot give a different picture. These are supposed to be authentic. Now, such persons are called experts. So, the category of person, foreign law, science wale, art wale, identity of handwriting wale, opinion wale, then foreign law के बारे में science, there are about 10 category of persons who are enumerated in this section 45 के अंदर. There are various types of experts. Now, let us see the illustration. The question is whether the death of A was caused by poison. The opinion of the expert as to symptoms produced by the poison by which A is supposed to have died are relevant. So, when the allegations are made that year, the wife will give a statement, circumstances leading to his death. My husband went to the house of his friend with whom he had civil dispute for a dinner for settling the matter. He was hale and hearty. So when he had dinner thereafter, he never came. He was unconscious. So food poisoning ho gaya. Expert was appointed. The body became tail. So the expert will give opinion. ये food poisoning से मरा है. A particular. So his certificate will be valid here. So the wife, it is corroborated by the statement of the wife that her husband went to his house under the pretext of settlement. Settlement के बहाने उसको खिला पिला के मार दिया साथ ताकि he doesn't claim it. So the expert opinion will be relevant here in this matter. It's of a corroborative piece of evidence. Number two, the question is whether A, at the time of doing a certain act, was by reason of unsoundness of mind incapable of knowing the nature of the act and that he was doing what was either wrong or contrary. So this defense is taken under section 84 of the evidence of the Indian Penal Code. So what I did not know the nature of the act. I was suffering from insanity. I was suffering from schizophrenia. So such accused person taking the defense are they are acquitted. No, the court doesn't take into consideration it is not a culpable homicide amounting to murder, and he did not know the nature of the act. So उसके लिए the doctors who are appointed under the Indian Mental Health Act, uh, the civil surgeon gives opinion. Yes, what was his state of mind? Whether he was suffering from depression, whether suffering from insanity, whether he was suffering from a schizophrenia or a mental condition which he did not know the nature of the act. So, our doctor's certificate is very important for this man to come out because he has committed a serious offense of grievous hurt, a murder attempt to kuch bhi kiya murder. Some serious offense is committed. So he want to take this. Unsoundness of mind incapable of knowing of the nature of the offense is a ground available to the accused person under the Indian Penal Code. All of you know that. Okay. The doctor certificate उसके लिए इंडियन में लॉ है the Indian Mental Health Act, which has was a 1985 act. Now it is amended and replaced recently 2 years ago. Just check it up. उसमें provision दिया गया. I have a copy. I'll find out. I have a Mental Health Act. Give me 1 minute. Now the act is known as Mental Health Care Act of 2017. This is the new act now, under which very strict guidelines are mentioned. उससे पहले जो act था, दो तीन act have been repealed. That I will tell you, Indian Mental Health Act था 1985 का. Yes, authority rules here यहाँ पे. You should be in a position to know this, all of you. Rules Act, let me complete the act. Yes. Now यहाँ पे repealing act. The earlier act was the Mental Health Act 1987, which stood repeal. उससे पहले Indian Lunacy Act was there. So you know that here under the provisions of section 82 onwards पढ़िए Indian Penal Code का, this a valuable defense is taken by the accused person. Yes, section 82, 83, 84, 80 से ले लीजिए आप. Yeah, general exception 76 से start होते हैं. Act done by bound by the mistake of a person, judges here accidental 80. देखिए act of a children 83, act of unsound mind 84. Nothing is an offense which is done by a person who at the time of doing by reason of unsoundness of mind is incapable of knowing the nature of the act or that is doing what is either wrong or contrary to law. Section 84 के अंदर an issue will be framed, a charges a murder against him. He will take up the plea that at the time I was a person of unsound mind. So in that event, the burden will shift under the Evidence Act. Shifting of the burden, he has to prove it with the help of the experts. The Mental Health Care Act of 2017. Please remember this. That illustration will be useful to you. Okay. Next, आ जाइए. Yeah. Next, see. The question is whether a certain document was written by A. Another document is produced which is proved or admitted to have been written by A. So यहाँ पे A का document which is sought to be produced in the court of law is under dispute. Now there are certain earlier documents which are on record. Earlier documents, under the provisions of section 33 of the Evidence Act, they can be produced or earlier document can be produced. The opinion of the expert on the question whether the two documents were written by the same person or different person are irrelevant. So your brother has produced in the court of law a will claiming to be a genuine will of your grandfather and you are disputing it. And you say that I have the letter of my grandfather and the passport and the signatures are differing. So the disputed document is the will and the another document, admitted document by you is a passport. Passport is a document. So the expert will be called upon to compare by virtue of the clause C as to whether there is a similarity, whether they are identical. ये दोनों comparison करेंगे इसके अंदर and he will give his opinion. Okay, that the expert opinion will be useful in this regard. Yeah, 1 A, B, C, D illustration आ गए इसके अंदर. Okay, that is section 80. Yeah. 44. Section 45 okay. Yes. Anybody want to ask me any question? So the examples are the DNA report, medical report, handwriting expert, medical evidence, conviction based and expert, and CRPC के अंदर provision है for examination. There are experts known as ballistic experts. You must have heard this. जब आग लग जाती है फायर आर्म डिटरमिन करने के लिए अंडर द आर्म्स एक्ट के अंदर ये बुलेट कहाँ से निकला, ये कौन सी कंपनी का है, इसका साइज क्या है. So the experts who go give opinion, they are known as ballistic experts. Please note that. Then there are also expert known as ocular testimony, ballistic report. Ocular जो आंख से देख के बताने वाले. Then medical report, which is not a ballistic report. Then there are experts who are architect, for determination of a mean profit under the provisions of the Code of Civil Procedure. You may take up the plea that the possession, the A is a trespasser who is in possession of your occupation and premises, you have sought a decree, namely, he should be ordered to quit, vacate, hand over, and quite vacant, peaceful possession of the premises. Number one. Prayer two will be that this honorable court be pleased to order and decree the defendant trespasser to pay compensation at the market rate as he has been occupying your property free of charge, and it cannot be done. So mean profit mean profit normally the court doesn't give immediately when a decree is passed. Now except now under order 15A in Maharashtra there's a provision, if a suit is filed by lessor and landlord, admittedly if a tenant is in occupation, a tenancy having been determined, license is being determined, the court can on the basis of certain reports can give also mean profit at the interlocutory stage. Otherwise, normally under an inquiry is instituted by the civil court under order 20 rule 12C. Please underline this and remember this. When a suit is filed for recovery of possession, a decree, the court has passed a decree in your favor, or a tenant has sublet the premises without your consent and permission. So the subtenant is using the premises and both of them are profiteering from your property. They are bound and liable to pay you the mean profits. That is what is exactly the market rate that you cannot determine. I cannot determine what is the rate. I'll just close this. This is causing me some problem. So when the decree is passed, the next step will be the court will institute an inquiry under order 20 rule 12C. That is the time you have to file the report of the architect. A valuer who will file that this is the age of the building, this is the area, this is a very spacious flat commercial premises near Taj Mahal Hotel or Delhi ke andar, very vicinity, really railway available, school is available, and it's a posh area. And I have made comparative rents of the area. I have seen the last rent which was paid, and I have seen the last sale. Yes, of cumbersome. The expert report, the report of a valuer, an architect report, will be submitted for determining the valuation report. He is an expert, so that report will be subject matter of dispute. Of course, you have a right to lead your own architect's report. The court will ascertain whose report to be accepted. Please remember this. Okay. Next is Skandar. There are also experts in the typewriting ke bare mein bhi there are experts. Whether a typewriter which is written is use is of a is of a is the particular typing has been effected from the Remington typewriter or old typewriter, new typewriter. uh, Fabrication होता है ना fraudulent documents से, ये सब क्वेश्चंस इसमें आएंगे इसके अंदर. Then footprints के fingerprints के बारे में, fine arm expert, DNA expert, these are all experts under the Evidence Act, who can be examined in the matter. Okay, there are also a narco analysis test, brain finger mopping test. So you know this all you have learned. Nowadays scientific test. A person is not telling the truth. Of course, they come on within the mischief of Article 20 sub clause 3 of the Constitution. You cannot compel the you cannot compel the person to go for a narco analysis brain mopping test. But at the same time, sometime the courts are ordering it. Uh, Many courts have ordered this kind of morphing test here. Of course, the Supreme Court and some judgments they are not approved this idea. You cannot a person cannot be compelled to give testimony against his own self. So then there is narco analysis. Okay. Then there are tests determine whether NDPS Act के अंदर narcotic drugs है या नहीं है. You have to examine the person. What is the percentage of opium present in this matter? Morphine कितना present है इसके अंदर? Certain quantity of morphine is allowed, certain quantity not allowed. Then these are all experts. Please note that you examine. Then their expert is a photographer. You need to take a description of a particular photography, a description of a building, of a property. So you require photograph. Huh? The photograph evidence is admissible in evidence. Number one, you the negatives are produced in the olden days. The negatives are produced and the photographer who took the photography is steps in the box and case I have taken it. Now with the advent of science in your mobile phone, आपकी खुद documentary आपने लिया, it's a primary document. If you give evidence, it is your primary document. Suppose from your mobile phone, you have transferred the message to my phone, your friend's phone, that photographs cannot be said to be original photograph, and you require to prove them under section 65B of the Evidence Act by taking the certificate of the information technology officer following the Supreme Court judgment in a Paraus case. That is not that here. So from your own mobile phone लेंगे आप, no problem. That is how. Then you have certificate of a doctor on plain paper. Now under the provisions of Order 26 Rule 1, if I am not mistaken, a person may produce a doctor certificate. Doctor certificate must be accepted by the court of law. The courts are giving importance to doctor certificate. But when a doctor certificate is false, frivolous, the man is not sick and doctor ne bogus certificate, you have a right to cross-examine him under Order 19 by making an application, isn't it? So the medical evidence ke baare mein you can challenge it here. That is law is there. The certificate of a doctor can be questioned, but though it is a primarily the court, normally in small matters, a person is sick, unable to come today for giving evidence, doctor given. The court accepts it. But it's a serious matter when an ex parte decree has been passed. The man takes up the plea. I have been perennially ill for several years, suffering from so and so disease. मुझे operation किया. It is challenge. The court will say that where are your medical reports? Show this. You just cannot just get a doctor certificate. आपने bypass surgery किया, you get these records. So the experts may be examined in that regard. That report must be given here. Okay. Yeah. Anybody want to ask me any questions on this 45? Please put it here. Then हम जाएंगे. Yeah, it's a very interesting section. Now section 46 पे आ जाइए अभी. 46 हो गया. Yeah. Facts bearing upon the opinions of expert, not otherwise relevant or relevant if they support or inconsistent with the opinion of expert when such opinions are relevant. Now see this 46 क्या कहता है? Facts bearing upon opinions of the expert. I mean, it must be the other fact, the facts which is trying to criticize or maybe appreciate the opinion. Facts not otherwise relevant, like it is a provision of section 11. Alibi evidence may facts which are not otherwise relevant become relevant. See, facts not otherwise relevant are relevant if they support or inconsistent with the opinion expert when the opinions are relevant. Now just kindly open your section 11 of the Evidence Act. Somewhat it makes something like this here. 46 में जो कह रहा है वही से कह रहे हैं. 11 section 11 check करें आप. Facts not otherwise relevant become relevant. See this here? I mean, there's an inconsistency. So you take up the plea, the prosecution says you are being arrested for an offense committed in Mumbai, and you take up the plea, oh, I was in Dubai. So you're leading evidence of Dubai, something which is inconsistent, which becomes relevant. So यहाँ पे similarly come back to section 46. 46 is somewhat उसी direction के अंदर है. 46 facts not otherwise relevant or relevant if they support or inconsistent with the opinion of expert, which opinion are relevant. So you can prove that this man is not an expert, his qualification is not true. He claimed he has passed out from Cambridge, but इसकी डिग्री तो मालूम क्या नाम चेंबूर की है, मुंबई की है. From Ulhasnagar degree, he is not even competent man. So something inconsistent, you can prove it here. Let us see that. Let us see the illustration. The question is whether A was poisoned by a certain poison. ये poison के बारे में है. The question is whether A was poisoned by a particular poison, a rat ka poison, a poison which is a chemical which is harmful. The fact that other person who were poisoned by that poison exhibited certain symptoms which expert affirm or deny to be symptoms of the poison is relevant. तो यहाँ पे the poison which was administered to A is somewhat similar to the poison which was administered earlier to other witness, other person, is also relevant here. This is one. Then the question is whether an obstruction to a harbor is caused by a certain sea wall. Oh, the question is whether obstruction to a harbor is caused by a certain sea wall. समंदर के अंदर कोई wall है, क्या ये was it obstructing the ways and free passage of ships के बारे में? The fact that other harbor similarly situated in other respect, but where there was no such sea wall, began to be obstructed at about the same time is relevant. So the current of the water is such in Bay of Bengal. So यहाँ पे बात हो रही है the Arabian Sea के बारे में. So evidence is sought to be led something of Arabian Sea in Bay of Bengal in a similar curve which the ship take, a similar incident take place. So something with the inconsistent evidence, it is otherwise not relevant. So we are talking of the evidence with regard to Bay of the Arabian Sea, which is between Mumbai and Kerala, and we are talking about the Bay of Bengal, which is in Calcutta and Bihar side. So the experts can give evidence to show that here even assuming there is no wall, such impact can take place. That is what the depends upon the geographical imbalances and the expert opinion in that regard, though the expert opinion differs here. So that fact may be not relevant here. Is otherwise becomes not relevant, becomes relevant. So it is not something, it may not be the support or they are inconsistent with the opinion of the expert when the opinion are relevant. So there is inconsistency in that regard, but the inconsistency proves that that has happened there in the Bay of Bengal, and वहाँ पे obstruction similarly it has happened even without. The undercurrent of the water is such that that is the opinion which is totally, what you may call it here, not consistent with the earlier facts, not consistent with the other evidence. It takes a somersault. So it may become relevant in certain circumstances. Like under section 11, so I told you that here the evidence, the offense is committed in Mumbai and you were in Calcutta, and evidence is led with regard to that inconsistent to prove your alibi. So यहाँ पे भी some similar things must have happened. The undercurrent of the water in the Bay of Bengal as well as in the Arabian Sea, when it is encountering obstruction in the harbor, it causes. That is the opinion that is relevant, and that is what section 46.6. Yeah. Mm. Yeah, sufficient weightage should be given to the doctor who conducted the postmortem as compared to the statement found in the textbook. So यहाँ पे मोदी का टेक्स्ट बुक में कहेगा आपको कि this kind of things may happen when a postmortem is conducted. So that is produced and argued by a defense counsel or maybe prosecution witnesses. But ultimately, the person who conducted the postmortem, he will give the correct finding whether the dead body, whether the death has resulted on account of A factor, B factor. So preference should be given to the person who conducted the operation rather than the bookish knowledge. That is what it may say. Then the credibility of the expert witness depends upon the reasons stated in the support of the conclusion, but the data and material furnished which form the basis of this conclusion. So the expert opinion is evaluated on the basis of a data. So the courts come to know what is the opinion which is given by the expert. Does it have any strength? He is a man with experience. Huh? One such matter, I'm just giving you one. Muhammad Jahid was a state of Tamil Nadu. is an important case law on the point in this regard in section 47. In this case, the credibility of a doctor's opinion conducting the postmortem vis-a-vis the statement found in the test book was compared. So the doctor gave one opinion, a very competent doctor, very eminent doctor, and his opinion is whatever his report is totally inconsistent with what is mentioned in the one textbook. Then the prosecution made suggestion to the doctor on the basis of statement found on the authoritative textbooks. The doctor disagreed with the statement of the authoritative test, giving reasons. The doctor has conducted the postmortem. No other authority was produced in support of the opinion. So the evidence of the doctor was self-contradictory regarding the opinion about the cause of death and could not be relied. So the Supreme Court, the court rejected the opinion of the doctor who could not give explanation in this regard. So the authoritative textbook of an eminent author was relied upon. The court, it is a subjective satisfaction of the learned judge sitting on the trial, because he comes to know what is the weight of this witness, whether he is telling the truth, whether he is telling the falsehood, whether he is a competent witness, a non-competent witness, you come to know. Similarly, when you are arguing a case, the judge will come to know you are a competent lawyer, having sound knowledge of law and fact or not, malum ho jata hai. You cannot fool a judge. Isn't it? So it depends the weightage of a lawyer. It's the weightage of an expert. What kind of evidence is giving before the court? What kind of submission a learned lawyer is making before the court of law? So the court will evaluate what exactly the same authority is sought to be argued in favor by the prosecution and being disagreed by the other side. The cogent reason given by the parties with explanation, with authorities, with judgment of the Supreme Court and High Court, and giving analogy, the court will accept it. So it's a matter of seeing the precedents. Who is presenting in a cogent manner, who is presenting the matter with great analogy, with great efforts. uh, Cogent reason, my expert cannot just come and bluff before the court. कि मैंने ऑटोप्सी किया है, मेरे अकॉर्डिंग टू मी इन माय ओपिनियन दैट कॉज ऑफ डेथ कैन बी, क्या नाम, गला दबा के मार दिया गया. गला दबाने से within half an hour or 1 hour or maybe 2 hours the person can die, but he's not being certain. But there are authorities, books like Modi's jurisprudence on medical legal problem. There are eminent authors. They given illustration, and these are books relied upon by the courts of law. Various several authors, Indian author, foreign author. So the witnesses, when you are confronting an expert, you must be well read. If you are not well read, you cannot be a good cross examiner. Conducting cross examination of an expert is a very difficult task. So, whenever I had to cross examine an expert, maybe an architect, maybe a doctor, autopsy, I always consult another expert, because I find out from the client and from them how this particular analogy and whether the opinion given by this man is correct. But what in your opinion? So you cannot be in a position to cross examine as a lawyer another expert doctor ho, a scientist ho, unless you sit across with another expert. Please note that when you may be a very brilliant lawyer, you may be knowing everything, but don't ever make the mistake of conducting cross examination or leading even examination chief without understanding the expert ka evidence and taking the help from another expert. नहीं तो कर पाएंगे नहीं आप. It's a very difficult art to cross examine an expert. I am now conducting some cross examination and leading evidence of a handwriting expert in Bombay High Court. I know that so many difficult times, 5, 6 people have fabricated conveyance, wills of one of the richest businessman from Gujarat and Mumbai, where I am handling for the matter. So how it is difficult? The evidence is going on for the last 2 years. It is not concluded. It's a very interesting matter. Of course, all of you, when you come in the court of law, you will experience all this here. So that is how. Section 46. Now 47 पे आ जाइए. Opinion as to handwriting when relevant. Now, when it is relevant? when the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of a person by whom it is supposed to be written or signed, that it was or not written or signed by that person, is relevant fact. It's very important. So a will is brought before the court of law, supposed to be signed by a grandfather of the plaintiff and countersigned by two witnesses who are known to him. All three of them are dead and gone. क्या करेंगे? When three of them are dead and gone, naturally the will come into play for probate when a person is dead. Witnesses must be examined. So to prove a will, one of the attesting witness must be examined. That is the requirement of law in section 68. पढ़ेंगे आप section 68 of the evidence. Proof of execution of a document required by law to be attested. Section 68 पढ़िए आप. When if a document is required by law to be attested, it shall be used as evidence until attesting witness at least one is called for the purpose of providing execution. So minimum what witness you must examine. अगर वो witness ही नहीं मिलेगा, मर चुका है, तो क्या करेंगे आप? Proof when no attesting witness is found 69 में आ जाएगा. If no such attesting witness can be found, if the document purported to have been executed in the UK, it must be proved to the attesting witnesses, at least in his handwriting or the signature of a person executing the document in the handwriting of a person. अगर वो भी नहीं रहेगा तो 70 will come. Admission of an execution of a party attesting. The admission of a party to attest a document executed shall be sufficient proof of the execution against him though. तो यहाँ पे यूजिंग द सेम एनालॉजी सेक्शन 47 कहता है if the when the court has to form an opinion as to the person by whom the document was written, signed, the opinion of the person acquainted with the handwriting. So a secretary of the your grandfather will know his signature. Your grandfather may be a director of a company, a very well-known man. Huh? He had a secretary who takes his signature, who does everything. He can say that he is acquainted with him, or his wife, his children, somebody who is not in dispute. Yes, this is a signature. So they can be examined before the court of law. And that is how section 47 says. Opinion as to handwriting when relevant. Then number explanation में a person is said to be acquainted with the handwriting of another person when he has seen that person write, or he has received document purported to be written by that person, or answer the document written by him, or under the authority and addressed to that person when the ordinary course of business document purported to be written by that person have been habitually submitted to him. So apart from the expert, the court will take into consideration the evidence of the person who is acquainted with the signature of another person, whose signature is a subject matter of dispute before the court of law. So the person, his secretary, his wife, familiar, if the family may dispute रहेगा तो some independent person or witnesses, his friends, they can be examined to prove this document. Let us see the illustration. The question is whether a given letter is in the handwriting of A merchant in London. तो ये लेटर इनकी हैंडराइटिंग में है नहीं है. B, a merchant in Calcutta who has written letters addressed to A and received letters purported to be written by him. C is B's clerk whose duty is to examine and file B's correspondent. D is a broker to whom B habitually submitted the letters purported to be written for the purpose of advising him the correspondent. The opinion of B, C, D on the question whether letter is in the handwriting are relevant. Relevant don't either B and C never saw the writing. So it is not only the expert, it is the persons who are familiar. So naturally the secretary who does the filing, he is familiar with the handwriting documents. Yes, this is my boss signature. And the agent and the principal who are in a relationship business under the Indian Contract Act, So they are constantly in touch. He is being praying, handwritten letter. उस जमाने में लिखते थे हाथ से. Yes, this is the handwriting of my agent or my principal. I am familiar with it. So they are also the persons who can give opinion as to the relevancy of handwriting in that regard. Please know that. So proof of handwriting by a person acquainted with the writing of the writer. So it is not necessary always an expert must give. Expert is a person who has not seen it. But these are best eyewitnesses. So these are the eyewitnesses. They call for their evidence is coming under section 60, which says that the evidence of a person who perceives it, oral evidence must be direct. See that oral evidence must be direct in all cases. That is to say, it refers to fact which could be seen, must be the evidence of a witness who says he saw it. It's the best evidence. Number two, it refers to a fact which could be heard, must be the evidence of a person who heard it. Number three, it refers to a fact which could be perceived by any other sense or in the other manner. It may be the evidence of a person who says he perceived it by senses or in the manner. The secretary might say that from the cabin I used to take his checks and everything. I couldn't see that. So provided the option. So 50, 60 ka requirement is being satisfied by virtue of the provisions of section 47. Okay, there are many cases and I would not dwell into it. 47A check लीजिए. Opinion as to electronic signature when relevant. When the court has to form the opinion as to electronic signatures of any person, the opinion of certifying authority which has been issued electronic signature is relevant fact. So under the provisions of a digital signature मिलेंगे आप इंफॉर्मेशन टेक्नोलॉजी एक्ट के अंदर सेक्शन 52C है इसके अंदर relevant section. Please note that इंफॉर्मेशन टेक्नोलॉजी एक्ट में सेक्शन 52 के अंदर है ये the authorities are giving signature. The court shall presume that the signature given by the authority is relevant. It will be taken into consideration. So 47A में कोई difficulty. Then 48, opinion as to existence of a right of a custom when relevant. So under section 13 हमने पढ़ा कि evidence with regard to evidence can be collected by the court and relevant to prove it. एविडेंस विथ रिगार्ड टू नंबर आ जाइए 13 के अंदर आ जाइए सेक्शन 13 facts relevant when right or custom is relevant. So you may take up the plea that here there's a right is in existence. Easementary right is right to egress. There's a custom in the community with regard to taking sat pheras and not taking it, or a person above the age of 15, 20 years can be taken in adoption, or there's a custom rituals taking place in a marriage or a death ke time pe in a particular community. India has so many castes, creed, and religion. So every community has a various custom. Customs and usages are law. Even under Article 13 of the Constitution of India, customs are recognized, given a statutory force. So they can be proved under Section 13. They can be proved by experts under Section 48. Even persons who are dead and gone under Section 32. मैंने पढ़ा आपको 32 relevant section is 32 7, that is a transaction mention, document relating to transaction mention 13. When the statement is contained in a deed, will, other document which transaction mention can be proved here, isn't it? Then yes, relating to transaction customs के बारे में कहाँ पे है देखो ये customs के बारे में specific section है relating to transaction person feeling matter.
It's 32(4),
Yes,
public right or custom.
yes. Giving opinion as to public right or custom. So the custom elderly man in the community, the gram panchayat के आदमी बताएंगे आपके. There's a custom in this particular. So there's a right of way the family, the village people are following. There is a jatra, there is a procession takes place every year, and all this public uses this private way to reach a particular mandir, देवी को चढ़ाने के लिए. So that right cannot be taken away. That custom cannot be taken away. So that right and even 48 recognize. Opinion has to exist in the way right of a custom when relevant. When the courts have to form an opinion has to exist in the any general custom, right? Opinion as to the existence of such custom, right person would like to exist in. Explanation: the expression general custom right include custom right commonly consider performed here. So, a section 13 applies to all the custom, general public, private so and so, 32(4) also with regard to custom. So, you should know these various sections. Okay, 49 पे आ जाइए. Opinion as to usages, tenets when relevant. When the court has to form an opinion as to usages and tenets of a body of men and family, the constitution of the government of a religious or charitable function, the meaning of the word term used in a particular district or a particular class of people, the opinion of persons having special means of knowledge are relevant here. So, what are the usages followed by a particular temple? अभी केरला के अंदर women are not allowed to go and visit the deity when they are menstruating. A particular that is what the belief of the people here. That is what here. Of course, the Supreme Court has a majority disagreed and minority अभी matter is pending in the revision क्या review के अंदर Supreme Court में. So whether the court will take into consideration what are the usages and custom, what are the men, religious people, charitable foundation, what they had to say about this custom, the court will take into consideration. So this will applicable section 49 के अंदर. Then come to 50. Opinion as to relationship when relevant. When the court has to form an opinion as to relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of person who are members of the family otherwise has special means of knowledge other are relevant. So this is also we rent under the provision the opinion as to the relationship under 32(5), 32(6) के अंदर पले थे हमने of the opinion. So the court can when the relationship is disputed, you can examine the various people who are known to the family members who as to who they are. Provided the opinion shall not be sufficient to prove a marriage proceeding under the Indian Divorce Act or prosecution under 494, 495, 496 of the Indian Penal Code. So the here opinion is not sufficient in the matter with regard to charges of bigamy, charges of adultery. In that matter, of course, by adultery, the charges have been minimized here. The court doesn't like to you require circumstantial evidence. But in the matter of proving relationship, the evidence can be used. Illustration check कर लीजिए आप. आज मैं 50 करके मैं बंद कर देता हूँ. The question is whether A and B are married. The fact that they were usually received and treated by their friends as husband and wife is relevant. So this is required to be proved here. Whether they have undergone a ceremony of marriage is irrelevant. They are staying together. The court presumes that they are husband and wife. Even she may be a mistress, but the law presumes they have been staying together. They are married couple. Then the question is whether A was the legitimate son of B. The fact that A was always treated as such by members of the family relevant. So you can remember some friends can give opinion. Yes, he has been the son because he is the one who admitted him to school, hospital, and colleges, maintaining marriage expenses. It cannot be said that he was unmarried. He had its son. So the elders in the community giving opinion that they were staying together. They were staying together as husband and wife, and the gentleman treated the youngster as his own son. Evidence can be led in that regard by virtue of section 50. 51 grounds of the opinion when relevant. Whether the opinion of any living person is relevant, the grounds on which such opinion is based on also relevant. Then an expert may give account of the experiment performed by him or purposes for forming his opinion. So the expert may be called upon to give the experiment. He may say that it is not the first time I'm giving opinion here. I have given opinion in such matters in Supreme Court, High Court, London, कहीं भी दिया हो, treatise I wrote down. He proved his credibility before the court. He is a trustworthy man. His opinion can be. So the opinion of an expert by itself may be relevant, but would carry little weight with the court unless it is supported by clear statement what he noticed upon. So that will add an embellishment to his career. If you say that many people say that he's a man, he's a surgeon come from America or London, so everybody will go to him. And he's a lawyer who is come from England and holding a degree from Oxford University. So many corporate people would like to engage him and take his opinion on international law, arbitration law, and that is how the system it works. So this man may be having extra knowledge. So that is how all about the expert opinion. Then yes, कहाँ पे आए हम लोगों ने section. I will like to stop it here now.
Sir, we did 51.
Okay, ठीक है, इतना बस काफी है. 52 character evidence कर लेता हूँ मैं. Tomorrow I am prepared to take. Tomorrow also in the evening I am available 7 to 8. चलेगा? Is that okay? Or you want
Yes,
little?
sir. Yes, sir.
7 के बाद 7
7
that
to
is
8 is fine.
ले लो. Even if you want, because I'll be working tomorrow. Monday I may not be available. Monday का दिन I will take Tuesday, Wednesday, Thursday लगभग. Okay. So tomorrow I will take. Even Sunday का
Sure.
नहीं. Tomorrow I'm available. Tomorrow I'm available 7 to 8. Okay. Anybody want to ask any
Okay, sir.
question? Quick
Okay, sir.
question, I'm there. Otherwise tomorrow. Because I have to attend some urgent meeting, arbitration meeting. Shall I call it a day? Tomorrow, keep your question ready tomorrow. Okay. Good night.
Sure, sir.
Good night.
Good night, sir.
Good night, sir.